Good evening. So in our assignment in Pale, we were given 6 scenarios to choose from and we are to choose 3 scenarios to answer. I chose to answer scenarios number 2, 4, and 6. So the facts in scenario number 2 is as follow. You are assisting a client in a mediation proceeding. During the proceedings, the mediator makes a doctrinal statement about the rights of the parties which is erroneous but which is favorable to your client's cause. Will you correct the mediator and state the right doctrine, or will you just keep quiet? Why? In my position, I would not keep quiet and state the correct doctrine. In if I It is because if I choose to use such erroneous doctrinal statement, even if I know that such doctrine is wrong or incorrect, I could either I could only be either of the following. Number one, an incompetent, or number two, a dishonest person. In option number one, being an incompetent, rule canon 18 of the Code of Professional Responsibilities provides that a lawyer shall serve his client with competence and diligence. So if I choose to ignore it out of my incompetence, I would violate rule canon 18 and and act upon the cause of my client with such undiligent act or incompetent. However, if I choose option 2, which is to be dishonest, it would result to a violation of rule 1.01 of the Code of Professional Responsibilities, which states that a lawyer shall not engage in unlawful, dishonest, immoral, or deceitful conduct. So if I choose not to correct such error, even though I know the correct answer or the correct doctrine, I would be dishonest not only to the courts but to my own and to my client. It is because it is my responsibility as a lawyer to be a slave to the truth and to justice. So, in order not to violate any any code any provisions of the Code of Professional Responsibilities, I only have one choice, and that is to be honest and to correct the mediator from his erroneous citation of doctrinal statements. So for the second scenario I chose is which is scenario number 4, it states the following facts. So in scenario 4, in preparing for mediation proceeding, you learn that the mediator assigned to the case of your client is a married girl with whom you have an extramarital affair. Will you reveal this to disqualify her or not? Well, this is a tricky one. Either way, I have conducted this immoral act already, which is a violation of Rule 1.01. However, in the current instance, I would not reveal such fact. Why? It is because of Rule 19.01, which states that a lawyer shall employ only fair and honest means to attain the lawful objective of his clients and shall not present or participate in presenting or threatening to present unfounded criminal charges or to obtain an improper advantage in any case or proceeding. In this current case, since it was my fault, it is my dishonesty or my immoral act that has uh, it is my immoral act to have an affair or an extramarital affair with the mediator. I should not use such fact to obtain an improper advantage for my client's cause because Rule 19.01 provides fair play And by doing so, by influencing the mediator, by threatening him or her, by threatening her in revealing such immoral acts that we have committed, would violate such fair play. And Rule 19.01 provides the prohibition to such. So I would rather not say or state such facts or threaten her with such facts. So in the last scenario I chose, which is scenario number 6, the facts are as follows. So in a family dispute under mediation, you are assisting the defendant husband who has been accused of failing to support his wife and child in the mediation proceedings. You witness the gross imbalance of power between the wealthy and the articulate husband and the destitute and inarticulate wife. The proceedings have become an opportunity for the husband to browbeat the wife and to put her into intense psychological pressure. The wife cannot even afford to hire the services of a counsel. As assisting counsel for the husband, what will you do if you do anything at all? So, I would rather uh, advise my client, the husband, to just settle and to avoid the controversy. Under Rule 1.04, a lawyer shall encourage his client to avoid and or settle a controversy if it will admit to fair settlement. So in the current case, this family dispute, there should be a fair settlement here. First of all, it is his wife. It is his duty to support his wife and his child as the father of the family, and to use such advantage in economic standing or in his educational standing is immoral and very wrong. I would just advise the husband here to end it all and just settle. It is in my opinion that the settlement or the support that the wife and the child would get from the husband is just fair. And if the husband would ask me to delay the case or to harass his wife, I would discourage it. Because under Rule 1.03, a lawyer shall not for any corrupt motive or interest encourage any suit or proceeding or delay any man's cause, which the husband would want me to commit. That would be all. Thank you.